Hello everyone. Hello everyone. Today we are going to present about PKWT to PKH, analyzing the court case of 8 Pdt.Sus-PHI 2015 PNDPS. And our group consists of me, Allyshia Zhafira, and Monika Larasati Putra Gomez, Putu Ariesta Sari, Giselle Emanuella Rumimper, and Raden Fresina Aisyah Choerupriyatna. Okay, next I will be discussing about the type of dispute. So first is about the termination of employment dispute or perselisihan PKH. PHK. David is a foreign worker hired with a PKWT that still has a probation period. The question is, can a fixed term contract for a foreign worker legally include probation, or is that clause invalid under Indonesian labor law? So we challenge the legality of his dismissal. PHK was imposed because of frequent lateness and previous working letters. This fits Article 1 UU 2004, dispute on pengakhiran hubungan kerja between worker and employer. The second is about rights dispute or perselisihan hak. After the PHK, Budi and the company disagree on his entitlements, where severance pay, uang pesangon, long service award, uang penghargaan masa kerja, and compensation of rights, which is uang pengganti hak. This is a right dispute under Article 1(2) of UU 2004, existing rights in the manpower law, UU 13, 2003, and company rules are not fulfilled because of different interpretations.
Now, moving on to what industrial relation dispute process have been carried out. First, employment relation. David, a French national, worked as an executive chef at Le Méridien Bali under a PKWT arranged by PT Tiara Raya Bali International. Second, determination. David did not attend work for 5 consecutive days without explanation, and the company sent 2 written summons on 24 April and 27 April 2015, but he did not respond. Based on the prolonged absence, the employer declared David to have resigned by operation of law under Article 168, Paragraph 1, and terminated the employment. Third, legal proceedings. David filed a lawsuit to PHI Denpasar demanding salary arrears, compensations, and other monetary claims. The company raised exceptions, relying on the PKWT's probation clause and the worker absence. And lastly, IR Forum. The PHI examined that the dispute under perdata khusus or perselisihan hubungan industrial, and there was no bipartite negotiation or mediation prior to litigation because the employer treated the matter as resignation under Article 168.
Next is about the main issues. So first is the validity of the PKWT, where David is a foreign worker hired with the PKWT that has a probation period. The question is, can a fixed term contract for a foreign worker legally include probation, or is that clause invalid under Indonesian labor law? Second is the legality of the PHK. Next, David was absent for 5 working days in a row that didn't give any written explanation and ignored 2 written summons. The issue is whether under Article 168.1 of Law 13, 2003, the company can treat him as having resigned. Third is entitlement to compensation. Finally, we ask if the contract is problematic and he is considered to have resigned. Is David still entitled to things like the remaining PKWT salary, monthly compensation, unused annual leave, airline ticket reimbursement, and other payments? These 3 questions guide our analysis of the case.
Now moving on to the fourth question regarding the legal consideration. First, PKWT was a void ab initio because probation is prohibited. Article 58, paragraph 1 until 2 manpower law explicitly prohibits probation periods in PKWT, including for foreign workers. PT Tiara Raya Bali International inserted a 3-month evaluation or probation clause. This violates Pasal 58, the PKWT becomes batal demi hukum. PHI therefore rejected the company's exception. Second, workers' conduct fulfilled Article 168, paragraph 1, deemed to resign. Under Article 168, paragraph 1, Undang-Undang 13, 2003, a worker is deemed to have voluntarily resigned by operation of law if absent 5 consecutive days without explanation, despite 2 written summons properly served. All elements were fulfilled. PHI accepted evidence showing David was absent 5 days straight. 2 written summons were delivered, and no explanation or communication was given. Thus, under Article 161, Paragraph 1, the employment relationship terminated by law due to workers' voluntarily resignation, not unlawful PHK. Moving on to the third elements, the consequence worker is not entitled to compensation because David was deemed to have resigned, no pesangon or severance, no remaining PKWT salary, no damages under Article 62, no ticket reimbursement. This is consistent with Article 168, Paragraph 3, which excludes compensation for workers who resign due to prolonged absence. And lastly, both parties violated the law because fair decision to reject both claims. The employer violated Article 58 for including a probation clause, but the worker violated Article 168 by abandoning his job. Therefore, PKWT is void ab initio. Lawsuit and exception are both rejected. Only cost to be paid is court-free. The reasoning aligns with judicial impartiality standards in Article 5, Undang-Undang 58, 2009, and with Arto's theory of judicial reasoning, including facts, the legal analysis is fair in conclusion.
So moving on to the decision itself, there are three main points that are highlighted. Firstly, Article 58, where the court rejected the company's exception, meaning the company's objection was not accepted because the PKWT was found to violate Article 58. So on this point, the court decided with the employee. Second, Article 168, Paragraph 1, however, although that is the case, when assessing the substance of the lawsuit, the court rejected David's lawsuit in full on the basis that he was considered to have resigned under Article 68, Paragraph 1. So this means legally, David was treated as if he resigned voluntarily. And lastly, void ab initio, which means the court then declared the PKWT void ab initio or batal demi hukum, or also meaning invalid from the beginning. Despite that, the court still ordered David to pay court costs of 446,000 rupiah, and there was no award of severance pay, compensation, or damages for him.
Now, moving on to our group analysis and opinion. So for our first opinion, we're going to talk about how the decision correctly balances employer and worker obligations. Now, in the case, the PHI avoided a one-sided judgment by recognizing that both parties violated statutory rules. For example, the employer improperly imposed probation in a PKWT, and on the other side, the worker breached fundamental duties by abandoning his post. And this balanced outcome maintains fairness and also upholds the integrity of labor law. Second one is that PHI applied Article 168, Paragraph 1 appropriately and consistently. Article 168 is strict and objective. Once its elements are satisfied, resignation occurs automatically. And this protects employers from operational losses caused by unexplained prolonged absence, while ensuring due process via mandatory written summons. The court correctly enforced this mechanism. The third one is that void ab initio PKWT is doctrinally sound. Declaring the contract void due to the probation clause demonstrates judicial commitment to protective labor standards, especially for foreign workers who might face unequal bargaining power. However, the void contract cannot override David's misconduct. A void PKWT does not entitle the worker to compensation when the worker violates Article 168. And lastly, the judgment reinforces important labor law principles, such as that PKWT must strictly comply with statutory form, meaning that any deviation or probation clauses makes the contract invalid. The second one is that workers must uphold basic obligations, such as unexplained absences carry serious legal consequences. And third, that courts must maintain neutrality, which means that refusal to reward unlawful conduct on either side.
So to conclude, the decision of the PHI Denpasar in this case demonstrates a judgment that is legally coherent, doctrinally sound, and balanced.
The court reached a conclusion that reflects both statutory compliance and fairness to both parties. Firstly, the court invalidated the unlawful PKWT. This confirms that employment contracts must strictly adhere to legal standards and employers cannot exploit fixed terms agreements to avoid workers' rights. Second, the court enforced strict rules on prolonged absence. This highlights that although workers have protections, they also bear responsibility. Consistent attendance remains a core obligation. And finally, the court denied compensation because neither party fulfilled the legal requirements. This ensures that remedies are not granted automatically. Compensation must be grounded in clear legal entitlement.
That wraps up our presentation. Thank you for listening, and bye-bye.